We are here for the motion for order to show cause. Mr. Madsen, go ahead.
Yes, Your Honor. Steve Madsen on behalf of Janice Grub. Ms. Grub moved into the residence at issue here in either late September, early October. The facts of the case are laid out pretty well in the declaration of Janice Grub and the declaration of Tasha Kelly, who was a roommate at the time and had been living there for some time prior to that. There's text messages that indicate that Sheila Soto was aware that Ms. Grub was moving in and did approve that. Although there's really no information as to what there was no lease in place at the time for either Ms. Kelly or Ms. Grub. In December, Ms. Kelly informed Ms. Soto that she was moving out, and Ms. Grub chose to stay. Ms. Soto was not, for whatever reason, was not comfortable with that situation, and had the water shut off on the 1st of January, when both with Ms. Kelly's help and Ms. Grubb went to the city of Longview to try to get the water reestablished, and they were told that only Ms. Soto, as the property manager, could authorize that. And since that time, she's been living there without water service. She has an 11-year-old child that lives there with her as well.
Let me ask you this, and
Yes,
I'm
sir.
just going to say I don't disagree that this is a concerning issue that the court has to address and address fairly quickly.
Yes.
But I do question if we have the right defendant. So could you address briefly why you believe plaintiff has sued the right defendant, so property manager versus true landlord?
Of course. And I'll start with 5918-300, which is the basis of our claim, which the first line of that statute says, it shall be unlawful for a landlord to intentionally cause termination of any of his or her tenants' utility services, including water, heat, electricity, or gas, with some exceptions for repairs. So the only issue is, in this case, in my opinion, the only issue is Ms. Soto a landlord? And then that takes you to RCW 5918-030, Section 9, which clearly states landlord means the owner, lessor, or sublessor of the dwelling unit. In addition means any person designated as representative of the owner, lessor, or sublessor, including but not limited to an agent, a resident manager, or a designated property manager. And so under the purposes of the statute, they are the landlord. And that's set up intentionally so that owners and landlords and tenants don't necessarily have to engage in direct contractual negotiations. And so I really don't see any basis for the claim that we're suing the wrong person. In fact, we're suing exactly who the statute provides for us to sue. I believe the owner of the house lives in Las Vegas or something, if you look at the Cowlitz County parcel report. But I don't know that. And yet again, that's why the law provides for property managers to hold the place of the owner for these kinds of purposes, because the owner could be anywhere on planet Earth, literally.
Okay.
That's all I have.
Okay. All right, Ms. Kazmaier, go ahead.
Thank you, Your Honor. I have a cough, so bear with me.
Okay, no problem.
So as you're aware, I came in on this case pretty late last week. We haven't filed an answer yet. We filed a 12B6 motion to dismiss prior to filing an answer. Our position is that Ms. Grubbs is not a tenant. So I'll kind of go through that. And as not a tenant, she doesn't have the protections of the RLTA, and so thus she's operating under common law. What our essential position is that Miss Kelly was a tenant of the property. She had a rental agreement, which is an agreement for use and occupancy. She asked for modification of her rental agreement to allow her to have a roommate, and Miss Soto agreed. Sure, you can have a roommate. That's a modification of Miss Kelly's rental agreement. It doesn't create a rental agreement with Miss Grub. When Miss Kelly moved out, Miss Soto never affirmed a rental agreement with Miss Grubb. She told her she had to apply. She gave her the notice to apply or vacate, she didn't do so. The information provided by by Miss Grubb, showing the emails from the city indicate that Ms. Soto said, we're waiting on an application, that Miss Grubb told the city that, or the PUD, that she didn't have a rental agreement. So our position is that she's not a tenant. If she's not a tenant, she's not protected by the RLTA. And if we're not protected by the RLTA, Ms. Soto's acting as an agent of the owner of the property, and she's not a landlord as defined under the RLTA. She's the property manager under common law. As we haven't filed our answer yet because we're waiting on our motion, that's kind of our position. I think that Ms. Grubb hasn't established a rental agreement. She's not paid rent since Miss Kelly vacated. So our position is that Ms. Soto is not a landlord for purposes of this action because the RLTA doesn't apply.
Mr. Madsen, go ahead.
Well, I mean, that's just not accurate. That's not an accurate statement of the RLTA. There's no requirement for a written rental agreement. There's nothing in the RLTA that says a rental agreement must be in writing. She took rent from my client when she moved in, when she began helping pay the rent when she moved in October. That constitutes the rental agreement right there. She can't then just decide, oh, I don't think you make enough money. I think you need to fill out a rental agreement, and then if I don't like you, I can eject you. I mean, it's absurd. This part of the problem here is that landlords are very well aware, since the rent increase cap went into effect, that they have a very difficult time raising rent for existing tenants beyond the 7% cap that currently exists. And that would apply in this case as well. So, Your Honor, it's our position that she was there, she paid rent, she was invited to live there, she moved in with her child, she's been there since October. And the only real and I would point out that if Ms. Soto wanted her out and not paying rent or whatever, she's got the opportunity to bring either an ejectment action under 5912, or if she wants to concede the RLTA issue, she can bring an unlawful detainer action under 5918. But she's done neither one of those. Rather, she's forced Ms. Grubb to live without water in a residence that would normally be considered uninhabitable. In fact, as we pointed out, the PUD had no problem putting the electrical account in her name. So all we're asking for today, we're not asking for anything else today other than to tell Ms. Soto to tell the city of Longview to turn the water back onto the house. And I don't think there's any, unless this court is willing to find today that the RLTA doesn't apply to Ms. Grubb, that's what we're asking for.
Okay. Ms. Casimiro.
Thank you, Your Honor. I'm just going to address briefly that when a tenant moves out, the statute that Mr. Madsen has cited does require the landlord to give any remaining occupants a notice to apply or vacate, and they can screen that person as they would any other tenant, prospective tenant for the premises, and they can deny their application. To argue that that's disingenuous or something that Ms. Soto is simply making up isn't true. She's required to do that if there's an occupant remaining who's co-resided for 6 months prior to that vacation of the tenant. I will note
I guess, so if I'm understanding the facts correctly, it was around December that the person originally listed on the lease said, hey, I'm out. So what's happened January, February, March, April? Has the landlord made attempts to eject or evict Janice?
And Your Honor, I'm not aware of any. Like I said, I'm new to this, so I haven't had time to dive in. I will say that I understand the request today is to turn on the water. Our concern is that turning on the water creates tenancy. And if our position is that she's not a tenant, we're fine if the court will include in their order that this doesn't, create a tenancy, and that will be determined at the outcome of this litigation. I don't think I understand it's, water is necessary, and I think my client understands that. So the concern really is that if the court grants this and we have to tell the city that she's a tenant to turn the water on, that creates a tenancy, which is not my client's position. So if that's, something we can include in the order, I think it would satisfy my client pending, what happens with this litigation.
Okay, so here's what I'm gonna do. I based on what's in front of me, and we all agree and understand that we are very early in this case. This is a motion for a preliminary injunction. I don't know now, especially now that Ms. Soto is represented, I don't know what ultimately comes out through testimony and if this is something that needs to go to fact finding. What appears more likely true than not to me at this stage is that this is an individual, Ms. Grub, who resided in the home with the agreement of Ms. Soto / the landlord. And it appears to me, again, more likely than not, that when the original tenant left, that they did notify the landlord that this other person, Ms. Grub, would be staying, that she has been allowed to stay. I guess maybe they've tried to force her out with turning off water, but no formal legal action's been taken in the 4.5+ months that she's been there without the original tenant. So I do believe at this stage, this early stage, more likely than not, that she would be likely to prevail at trial on the issue of having established a tenancy. That she does have a very well-grounded fear of her invasion to this very important right, which is a right to water service in the place that you live. And I think very clearly we would all agree that having said those first two things, clearly she would suffer irreparable injury if water service is not restored. I am going to grant the plaintiff's motion for preliminary injunction. It will direct water service to be restored to the 249 Oregon Way location. In the proposed order, there's language about not harassing, intimidating, threatening, or retaliating. I'm going to strike that language. I'm not going to order someone to do something that is already unlawful. So I'm going to strike that language, and I will include language that states that by complying with the court's preliminary injunction, well, let me say it this way. Defendant waives no arguments in fact or law by way of complying with the court's preliminary injunction order. I don't know that I have a original. I have the proposed. Mr. Madsen, would you be able to send over by Word document just your original proposed, and I will make the changes I just stated on the record?
Yeah, that's fine. No worries. I'll email it to your LA.
Yeah, and just copy Ms. Kazmaier on that.
Sure.
I'll make the 2 changes I noted, striking number 3, adding the language about not waiving any rights by complying.
Okay.
Okay, anything else the parties need to do on the record today?
Your Honor, we're not setting any further hearings at this point, correct? I mean, it's going to be, I'm assuming that Ms. Kazmaier will file her answer, and potentially counterclaim.
I heard that there might be a motion to dismiss that was filed. I don't have it scanned in yet, but
Yeah, I guess it'd be nice. I mean, since the motion to dismiss was essentially based on today's show cause hearing, I don't know if are we still going to go through with that again, or should we strike that?
that's not in
I'm not
front of
gonna
me.
strike it at this
I
point.
understand. I understand.
let-
I just trying to get the calendar clear for.
Okay. Perfect. Okay, well, I'll let you all handle that part. If you
Okay,
shoot me
fair
over the
enough.
Word document, I will get that order filed, and thank you both so much.
Thank you,
Thank
Your
you,
Honor.
Honor.
Okay.